Welcome to Talk Law Radio. I'm Todd Marquardt on the radio, on podcasts everywhere, on Facebook, and on YouTube. Also, visit talklawradio.com to check out the archived episodes. Today, we're going to be talking about guardianship and probate and something else, trust administration, reconciliation of accounts and accounting with senior paralegal Sharyl Mays. But first, it's the financial focus with Steve Warren with Financial Planning HQ. He's financial CEO for successful people who would rather do fun things with their lives than manage their subject matter experts like CPAs, financial advisors, and insurance people. So, Steve, welcome to the show.
Glad to be here, Todd. Super fantastic on this beautiful day, and it looks like it warmed up a little bit out
It
there.
has since the last time we met.
Yeah, on Saturday.
Last week, you were talking about the Apollo 11 mission and all the planning that went into that historic and mission, and how everyone should have a plan that has clear objectives, is comprehensive, has well-defined strategies, and has an action plan with specific details of what needs to get done by when and who's responsible for getting it done, and a process for course corrections.
Sure.
All of this in a written document.
Absolutely. Yeah, we call it a comprehensive written lifetime financial strategy.
Can you give our audience an example of a well-defined strategy?
Yeah, I can. We were talking about an actual written document. And first, I'd like to share with you the results of a recent survey that was done with financially successful people. And in this survey, 63% of the people surveyed felt that their financial advisor was not actively providing them with a comprehensive written lifetime financial strategy. In other words, something that's actually written, a physical document that they could give to their CPA and say, here, take a look at this. What do you think about it? So a lot of people just don't have confidence that they have a written plan. And we have a client that's coming in actually on Friday, a new client, a fairly new client. In fact, your firm did the legal work, their living trust, a while back. It's been about a year now. And so she has been wanting to retire for, I guess, 4 or 5 years. And she's just so dedicated to her, to her employer. And now she's actually going to retire. And so she's made up her mind. She's looking to retire in April of this year. And so I thought I would talk a little bit about the strategies within their plan that we're updating. We did one last year. And we fine-tuned it throughout the year. And now we have updated information. Their expenses have changed. And their discretionary expenses are probably going to go up because they're going to be doing more vacations, things like that, doing things that are fun. So here's some examples to answer your question, Todd, of, strategies illustrated. And the first thing that I mentioned here within their plan is that she stay the course and maintain actually retiring, because she has been talking about this for a while, and she just doesn't do it. So we gave a recitation within the strategies illustrated to maintain the retirement timeline. And some of the benefits of retirement, we actually wrote those out within the strategies illustrated. And those benefits are enhanced happiness, and there's reduced stress, the opportunity to do things that are altruistic, because she does have charitable inclinations, and those would be very healthy for her, rather than to go to work and be under such great stress. So you've got improved well-being, and then she can pursue her passions and interests. And some of the other strategies that I mentioned in taking a look at their cash flows, we actually recommended, and we give advice with conviction, Todd. So we actually recommended that they increase their discretionary spending by $15,000. So that's maybe an extra vacation or something like that, because their capital timeline can support that. So whether or not they do that because they're very good with their money, I don't know, but it is a recommendation. It's a strategy that actually does not affect their capital timeline in an adverse way.
That's awesome.
Yeah, absolutely. And within the Strategies Illustrated, we are at a point now where we're creating a very robust cash reserve plan for them. So we added um, some treasury bills that they add to what they currently have in cash reserves, which is money market and so on, and some treasury bills that are 13 weeks. They mature every 13 weeks. And so one of the strategies illustrated is to set up that account because that gets close to 4%. And it's really safe money rather than to put that in a checking or a savings account. And also, this client is going to be 65 pretty soon. So there's some big decisions that need to be made with regard to Medicare and applying for Medicare. So within the Strategies Illustrated, we gave her a roadmap of where she needs to go, what she needs to do, what she should think about as far as a Medicare supplement plan, and then the different parts, A, B, C, and D.
Right.
And so we will bring in a subject matter expert at our next meeting, which will be fairly soon, to talk to her about kind of navigate through that process of Medicare. It's not that hard to enroll, but when you're looking at a supplement, there's a lot of different options that people have to navigate through and, make a decision on. And we also recommended within the Strategies Illustrated that this particular client start her Social Security at normal retirement date, which is age 67, and I think it's age 67 and 7 months. So there's going to be a little bit of a gap in time. But when we test the numbers, that produces the best outcome for her to wait until her normal
Mm-hmm.
retirement date. And also, she has a couple of annuities that she bought a long time ago. And we're going to turn on an income from these annuities kind of to bridge the gap a little bit. We'll probably leave the income on permanently, but that'll allow her to, have a good income, no negative cash flows between now age 65 and age 67 and 7 months. So those are some examples of some strategies illustrated, just a couple of them. In here also, we did recommend that they freeze their credit. They have everything paid for, so we don't want anything bad to happen, like, somebody take out, I don't know, a cell phone in their name or just something like that.
Right.
So we do advise our clients to freeze their credit, and it's easy to do that, and you can easily unfreeze it in case they decide to buy a rental property or, something like that happens.
Right. I can see how a comprehensive written lifetime financial strategy would be empowering and comforting all at the same time.
Yeah, absolutely. And to go along with those strategies, Todd, what's really important is the action plan, the tactics, because those are all strategies, but action has to take place in order to, make those things happen.
Right.
You got to start your Social Security. You got to go through some documents in order to start an income from the annuities. You have to make a decision as to whether or not you want to have withholding on that income and all of these things.
Mm-hmm.
There's a well-defined action plan, and basically it says this is the action, who's responsible for completing it, is it us, is it the client, is it all of us together, the target date, and once those actions are achieved, then we check them off at that point.
This is Talk Law Radio. I'm with Steve Warren, CEO of Financial Planning HQ, and we're talking about comprehensive written lifetime financial strategy. Steve, last week we talked about course correction, and so I
Yeah.
want to give you a hypothetical. What if, God forbid, somebody with a plan like this has a sudden illness or an accident, and it seems like there might have to be a course correction? What are some things that you might suggest, or what would you look into?
Yeah, actually, that happened to a client recently. His wife was in a car accident and she was severely injured, her back, and has been in just a lot of constant pain.
Mm-hmm.
And this particular client, back when this happened, owned a business. And so we've actually live this out. And one of the things that we had to do is to, have a discussion about whether or not she would be cared for in the home and or in a facility. And it was decided that in-home care would be the best. And actually, our client, um, the spouse, is actually her caregiver to a
Okay.
large degree.
Hmm.
So she definitely wanted to stay home and she needs a lot of care. So the very first thing we did is to have a bonus meeting outside of what we normally have to talk about the situation and what is the best course of action. Sometimes if a person needs to go into a facility, that kind of changes everything.
Right.
Yeah, in this case here, their expenses went up because they have a nurse that comes in
Hmm.
for a certain amount of hours per day. And so in that situation, expenses went up by roughly $2,000 per month. So it first starts with a conversation. Decisions have to be made. Subject matter experts may need to come in to talk about some of these things that need to be considered.
Okay. Well, it sounds like that you're always there for them.
Yeah,
You had that
absolutely.
bonus meeting with them.
Yeah, absolutely. It's our role is to have the clients back. Yeah, that's
Awesome.
important.
Well, that's it for the Financial Focus. This is Steve Warren with Financial Planning HQ. Call what number?
210 685 2722. That's 210 685 2722.
Welcome to Talk Law Radio. I'm Todd Marquardt on the radio, on Facebook, on YouTube, on talklawradio.com. If you're watching on Facebook right now, this is Sharyl Mays, senior paralegal with Marquardt Law Firm. We're going to be talking about account reconciliation in probate, guardianship, and trust administration. We call those accountings, but I didn't want the people to think that we were talking about like bookkeeping or accounting for a business. So I, I'm going to use that term reconciliation a lot,
Okay, sounds good.
and you can explain what that means. But before we get started talking about the law, let's begin with prayer. Dear God, thank you for this day. Thank you for all the gifts and blessings that you give to us. Please forgive us for our sins, for our mistakes, for doing the wrong thing or failing to follow your will. Please help Sharyl and me give good information about probate, guardianship, and trust administration, account reconciliation. Help us to do everything we do for the good of your people, for our own good, and for your glory. In Jesus' name, amen.
Amen.
I want to begin, Sharyl, with introducing you to the audience.
Okay.
I know you've been on the show before, but somebody's probably getting in their car right now that hasn't heard from you yet. And we have a whole big Houston audience now, too.
That's great.
Yeah. So that's KNTH 1070 in Houston and 103.3 FM in Houston. And so I did some research on when you started working with us at Marquardt Law Firm. February 25th, 2020, you started working as an independent contractor,
I did just doing
helping me
accountings.
with the accountings. And then you began working with us full time October 5th, 2021. So it's been it's been 4 years and a little bit. But let's go back in time to when you first got into the business of law. Tell us how that got started.
So I was actually working at an oil and gas measurement company as a clerk, and they were subletting to an attorney that practiced probate. And I had been a lifetime friend with him. I'd known him since I was young. And he just said, "This is not what you're going to do with your life," and said, "Come work for me." And almost immediately put me on doing accountings for him. And so I worked with him for nearly 15 years. That's how I met you in the
Right.
process.
You were helping me with accountings.
Yes. And then he closed down his firm. I had the opportunity to work for a wealth management department at a local bank, still doing a lot of the things that I was doing within probate, and decided right before COVID to go open my own estate sale company, which was successful, but unfortunately COVID didn't allow it to go forward. And because I was working with you as a contract employee, it just worked out in God's plan.
Yeah, amen. And I started working with Sean when I graduated from St. Mary's. I took the bar exam, but had to wait 6 months for the results. And so he brought me in as an intern and gave me a little bit of work to do. And so I got to interact with you then as well. When he said he was going to work for the bank, I said, "Is Sharyl available?" And he said, "No, she's coming with me."
I appreciate that. That's very flattering.
Yeah. Okay, so you've been working in the industry. What year was that when you started working with him?
I started working with him in the fall of 2001, so we are a little over 25 years at this, or
Wow.
25 years at this point.
Yeah, this will be your 25th year.
Yeah.
That's great. You've been helping our clients get through these cases, and I'll let you explain how they feel, how hard it is for them to go through a guardianship and a probate and a trust administration. But I just want to lay the groundwork for all of your experience first. But besides all the work that you do, the good work that you do, let's let the audience know something else, a little more personal. You can say as much or as little as you want about what do you do for fun?
So right now, what I do for fun is mostly cuddle cows. My girls are very active in FFA for their school, and so all of our hobby right now is dedicated to the cattle and the livestock shows are coming up. We get to
Mm-hmm.
travel to San Antonio and Houston and Austin, and it's just a great opportunity to really dig in and support our kids and then our community. We've met fabulous people. We've gotten lifelong friends out of it,
Mm-hmm.
not just for ourselves but for our kids too. So it's been wonderful.
Great. Just to remind you, this is Talk Law Radio with Todd Marquardt. And now it's time to discover your legal issue blind spots by listening to me talk about the law on the radio. Cheryl, let's start with guardianship and just let people know sort of what that is and why it gets started. It's a court proceeding, right?
It's a court proceeding. It's really the last resort for individuals. The court does not like to be involved in people's lives. They don't want to be making decisions for people. So that's why we encourage people to get their estate plans done beforehand, get your power of attorneys, get the declaration of guardianship, and if it needs to come to fruition later, get your will done. The estate plan is such a easy and vital gift that you can give to your family now, than having them to go through this overwhelming, expensive, and emotional experience
Right.
down the line.
So in the olden days, you could have an employee or a family member be your agent
Mhm.
so long as you had the capacity to do the same things that you were asking them to do.
Right.
But if you lost capacity, then your agent would also lose their power to make decisions. And so that there were so many guardianships being created so that the court could appoint somebody to make those decisions and oversee everything that they were doing, that the state legislatures all over the nation passed the Statutory Power of Attorney Act
Mhm.
that allows the power of attorney to continue giving that agent power to make decisions even after somebody becomes incapacitated. But you have to sign it before you become incapacitated. I had somebody call me one time from the hospital. I think it was a wife. She said, "My husband fell off the roof and I need a power of attorney." And I said, "Well, can he sign and understand the document?" "No, he's unconscious." Well, it's too
It's
late.
too late.
That's when she probably needed to get guardianship for that.
Yeah, typically, if you're seeking guardianship, it's already too late for the power of attorneys and estate plan to be put in place.
Right. And so the reason we're talking about it today is because there's a statute, right, that requires guardians to account for how they spend the ward's money. The ward is the person who has lost the capacity to make decisions. And so I found the statute for final account.
So the statute for the annual account for guardianships is 1163 of the Texas Estates Code. And so the accounting is so important, not only to protect the ward and the assets of the estate, but also to protect the guardian and their fiduciary duties. Because if you don't do it per the Texas estate codes, you're in breach of those duties and you're personally liable for your actions that you take on behalf of the other individual.
Right. If the ward's money gets lost or stolen or you lose it all in the stock market,
Mhm.
then the guardian's responsible for that, and they might have to pay out of their own pocket to make the ward whole again.
Yeah, and that's why the law requires that the guardian have a bond. So if something does happen like that, at least the ward's estate is somewhat protected.
So the bond is like an insurance policy that says if you get in trouble and you have to pay, then the insurance company pays on your behalf and then they try and get it back from you.
Exactly. That's exactly how I explain it.
Yeah. Okay, so you have to file an accounting. What exactly goes into that?
So the accounting for a guardianship really starts with the inventory. So a guardian has to be bonded and file an oath with the court. And once both of those two things are done, that's what we call their qualification date. And so that is the date that the inventory values are based on.
Of assets, not like of an inventory in their store, but an inventory of the bank accounts that they have and the stock accounts and their motor vehicles and their house and all that.
Yeah, vehicles, recreational vehicles. We have to go far into it and confirm title on real property to see if it's community or separate. We have to give all of that information to the court.
Mm-hmm.
And we have to verify it to bank statements. We just can't take our clients' words for it
Right.
um, because they don't know what they're supposed to be reporting. It's our job as the attorney to do that for them.
Okay, well, we have to wrap up this segment, but stay tuned because we're going to continue talking about everything that goes into the accounting. Cheryl was just mentioning we start with an inventory of the assets. Just remember, this is Talk Law Radio. We're on the radio, we're on podcasts everywhere, we're on Facebook, we're on YouTube. Stay tuned. We'll be right back. In the beginning, God had one law: don't eat from the fruit of that tree. Then he gave Moses the 10 Commandments. And now we have municipal, state, and federal lawmakers that won't stop creating new laws, laws that might impact you without you knowing it. So listen to Talk Law Radio every week on Saturdays at 11 o'clock in the morning and Sundays at 4:30 in the afternoon on KLUP 9:30 a.m. The Answer. Facebook Live, YouTube, you know where to find it. This is the third segment. It's the sinners and the saints. I love that song because Martin Luther, the famous theologian who nailed his 95 thesis on the church door, said, we're all sinners and saints. We're sinners because we were born into sin, but we're saints because of the death and resurrection of Jesus Christ. We're forgiven and absolved. And so I like to talk about somebody that's done something bad. We call them the sinner. And somebody that's done something good. We're going to focus on one of the case studies that you and I talked about, Charlie Thrash. It's a guardianship case. And so tell us what you know about it.
So, Mr. Thrash was a local businessman. At the time of the guardianship proceedings, he was 81 years old. He had been involved with a woman that wasn't his girlfriend when everything kind of started. Well, then she took him to the courthouse, got him married, took over his assets, and started spending them down for herself.
Hmm. And so somebody applied for guardianship. Who was that?
So my understanding is that one of the local agencies, either Adult Protective Services or Health and Human Services, stepped in on his behalf and applied that he was being exploited by this individual and that he needed a third party guardian appointed to help him.
Right, there was more than one guardian, and this case became famous.
It did. It was
Why?
all over the paper.
Why is that?
His estate was worth $3 million. I mean, he had vehicles, he had a car collection, he had a business that was successful that he had run for years. And she was not allowing family members to visit. He was not getting adequate care. And so the court deemed it necessary that they pretty much had to be divorced in guardianship.
Oh, the new spouse.
Yes.
Well, what I learned when I was researching this case is that this case was the basis for a Netflix documentary called Dirty Money.
Mm-hmm.
And you're not going to be able to find it on Netflix anymore. Do you know why?
Why?
Because one of the guardians, Tanya Barina,
Mm-hmm.
filed a lawsuit against Netflix for defamation.
Yeah.
And this is the surprise.
Okay.
So what I found interesting about this is I did see that episode before the lawsuit settled out of court. But what she said is the way that the Netflix documentary portrayed her was that she was the evil one,
Mm-hmm.
and their whole premise for the show was that there's an epidemic of guardianships in the United States, and all the guardians are taking advantage of the wards. And so the way that they did the filming and the questioning of her was portrayed her in a bad light. And so she filed the lawsuit and said, "Hey, this is wrong. You can't portray me in a bad light." And it went all the way up to the Court of Appeals, and because the trial court had denied Netflix's motion to dismiss.
Okay.
And the court said, no, there's enough evidence here to keep the case going. And that's when they settled with Tanya Barina. She had been asking the court to order that Netflix pay damages and $5 million. And the court settlement is confidential and it's not disclosed anywhere. But, it's within $5 million probably.
Probably. Well,
But-
I mean, we can definitely see that there's an uptick in movies about guardianships and estates. There's another movie called I Care.
I
that-
care a lot.
Yeah, I Care a lot, that it put guardians in a very bad light.
Right.
And, media does what media does and spins it to how they want it.
Right.
It's not the truth.
Right. And so the state legislatures and the courts have been making it more difficult for people to get guardianships. Our clients have to jump through a lot of hoops.
We have some guardianships that take years to get somebody appointed. Typically it's the attorney representing the applicant, the guardian, and an attorney ad litem that's appointed to represent the ward in the proceedings. We're seeing more and more about the family conflicts
Mhm.
that are causing these basic guardianships to go to litigation. And
Sometimes it's not about the money, it's about control.
absolutely, who has the most power?
Right. Because if they're not fighting about the money, they're fighting about over visitation.
We're definitely. I mean, and with family being so spread out, and different opinions, different beliefs.
Mm-hmm.
Nobody's going to agree, but when it comes down to it, the court wants the ward's best interest at heart, and the litigation doesn't serve a purpose for the ward.
Well, it's supposed to, though, to find the person who's best qualified, because some people have a good heart, but they don't know what they're doing.
Well, and that's why we have certified guardians. There's been a big swing in private citizens going out and getting the certifications so that they can step in and serve in those kind of instances.
Yeah. So it's a big job and it's a difficult job because now you're managing somebody else's medical appointments, where they live, how they spend their money, how they save their money, and how they budget their money and all of that. So that brings us to the accounting question. What what's required? What are all the things that go into the accounting that we have to submit to the court for approval?
So the accounting period is based on the qualification date that we spoke about, and it goes from 1 year post the qualification date. So say you're qualified on February 14th, it's going to go from February 14th through February 13th every year until that guardianship is closed, the individual passes away, if it's a minor when they turn 18, and you have to report every line by line of every
Mm-hmm.
account. You have to go into the county appraisal district, check the value of the real property to see if
Mm-hmm.
that's decreased or increased.
But I think that a lot of people don't know the level of detail that the statute requires. Not only how much you spent, who did you pay, and what was it for, but you have to have receipts and invoices and
And bank
things like that.
statements. And as a guardian, you can't just go and spend the ward's money at free will. You have to get court approval for anything outside of the monthly allowance that the court sets for you. So, a big storm comes through and blows down a tree. While you may think it's an emergency to get it cut up and hauled off, the court doesn't see it that way. You have to go through the process because if you don't, you're in breach of your fiduciary duty.
Right, and the somebody else could complain, another family member saying you're doing a bad job as guardian, or the court can remove you on its own motion.
Yeah, that's why we have two court auditors in each court. They go through the inventories, they go through the accountings, they go through the request to expend funds to confirm that you're doing the right thing for the
Mm-hmm.
ward.
And all of this is expensive. So you have to have an attorney walk you through this process every year if you want it to be done correctly. Otherwise, you're just going to be spinning your wheels, turning things into the court that they're not going to accept.
Yeah, we've unfortunately seen more and more guardianships come in that we weren't initially the legal representative, but that they've been appointed guardian for multiple years and haven't been doing the accounting. And now the court is following up on these cases, and they're sending out show cause notices and saying you need to come into court and explain why you're not doing your job.
Right. So that's guardianship. We're going to be talking about probate next. Now, probate's the process where you transfer title from the deceased person to the living beneficiaries or the heirs, where you wrap up the deceased person's affairs and pay their bills. And sometimes you have to have accountings there too.
Absolutely. If in most cases when somebody passes away without a will, and there's an administrator appointed, they have to do an accounting as well.
Right. Well, this is Talk Law Radio, talking with Sharyl Mays, senior paralegal with Marquardt Law Firm. And when she's not at the office, she's probably wearing cowboy boots, cuddling cows.
I love them.
Tell us the name of some of the cows that you cuddle.
So right now we have Clover, who is our Black Angus heifer. She's about 6 to 7 months pregnant right now. Then we have a Limousine, who's a blonde steer. That's Bandit. And then we have a Hereford Smoky.
Awesome.
Yeah.
Well, this is Talk Law Radio, talking about accountings and reconciliation of financial things for guardianships, probates, and trust administration. We just finished guardianships. So after the break, we'll talk about probate and trust administration and legacy. Stay tuned. Welcome back to Talk Law Radio. I'm Todd Marquardt. This is Sharyl Mays, senior paralegal with Marquardt Law Firm. She helps us with all of the required accountings in the probate court and guardianship and trust administration. We already talked about guardianship, so we're going to focus this time on probate administration and trust administration. Let's start with the worst and then get to sort of the best. What's the worst kind of probate administration in terms of frustration, cost, and time spent?
That would definitely be when somebody passes away without a will and the family or the potential heirs can't decide on who's going to be the administrator, and a dependent administrator has to be appointed by the court to oversee the estate. And just like the guardianship, you have to go to the court for approval for everything.
Right, you're dependent on the court.
Exactly.
And in some states in New Mexico, they call it formal probate because you have to go through all the formalities. And so we already talked about what goes into a guardianship accounting, and it's pretty much the same stuff that goes into a probate accounting.
It is.
You're just dealing with a deceased person instead of an incapacitated person. But just give us an idea of what that looks like. Somebody comes into our office, says, my loved one passed away, they didn't have a will, and we can't do anything because all the accounts are frozen, the property can't be sold.
So from that point, we just start gathering information because our job is to represent to the court who should have been the heirs of law when the individual passed away and what their estate is.
Right, the Texas Estates Code says who gets to inherit the property.
Correct. And so, if you died with a spouse, you would think that a spouse would inherit automatically, but that's not true. If you had children from a previous relationship, those children would take a higher interest than the surviving spouse. So we really have to sit down and do the family tree and see where it all falls.
I have a worksheet where I draw a picture. That helps me visualize and remember who's related and how. And it also matters whether it was community property or separate property.
Absolutely. So if there's separate property, you die with a surviving spouse with the children from a previous marriage, the surviving spouse only gets a 1/3 life estate interest in that separate property. And once they pass away, it goes to the decedent's children.
Yeah, it's really weird. 1/3 life estate. So we'll have to explain that in greater detail some other time. So let's say that somebody does have a will and they pass away, and the will says that they can have an independent executor that doesn't have to post bond, and they can act independently of the court. So in what circumstances have you seen and accounting needed there?
So that's best case scenario is passing away with a will, independent executor, no court supervision. The need for the accounting comes in. The need is always there. Whether you do a formal paper one and provide it to the beneficiaries is really the issue. So the beneficiaries, they have the right to a copy of the inventory and they have a right to the accounting. But there's requirements for them too. They can't demand it immediately. They have to wait for a 15-month period
Mm-hmm.
from the appointment date of the executor to be able to get that accounting. But as a fiduciary, it is always your responsibility to have those records on hand.
Right, because you have to act in the best interest of the beneficiaries.
Hmm.
And so you have to keep track of the money and the property and how it's being spent. And then you have to give them a copy of all the documents that they want.
Exactly. And beyond that, for us as your legal representative, we want to make sure that there's no tax consequences for the estate or for the beneficiaries that are inheriting too.
Mm-hmm.
So we help with all of that throughout the accounting process.
Okay, so let's say that somebody, while they were alive, they did superb planning. They said, I have my power of attorney, I have a will, and I also want to have a living revocable trust. And then that person passes away, names a family member to be the successor trustee. What are some circumstances where an accounting is needed or required in that situation?
Very similar to the executor being appointed. Your job is to always protect the estate and then be in the best interest of the beneficiaries. And so when there's multiple beneficiaries, that you have to be transparent to.
Mm-hmm.
That's the biggest thing, is the accountability and transparency to the beneficiaries. When you have open communications with them, it makes the accounting a little easier, but always necessary. And so with the trust administration, we're looking at different things like, is it a federal level estate? Because the trust is included in that.
Mm-hmm.
Do we need to push off distributions until we get a 706 return filed? Do we need to make some charitable donations to meet the gifting and tax deductions?
Right.
So there's a lot of different things that the accounting really does.
Well, I think it comes up when a family member has been appointed and they don't know what to do. We've had some cases where we saw a successor trustee who was just paralyzed with fear and didn't know what to do. And they thought about this every day for a couple of years before they finally called an attorney and said, I need help, because they're scared to death of paying fees to attorneys and accountants. And the beneficiaries would gladly pay those fees if you would just hurry up and get these things done. But there's a lot of things people don't know about how to get the things done. And so I think that's when it comes up. I also um, knew of a case where mom and dad had a living trust. They had plenty of money, but they both needed memory care. And the daughter that lived here in town, she took care of them. She arranged for the care to be paid for and provided. And she was, involved in their lives every day because they required a lot of attention. The son lived in California. He didn't do anything, he didn't visit until one parent died. And then after the second parent died, he said, well, where's my inheritance? And she said, I'll get it right to you. It's X number of dollars. And he said, no, it's not. Where's the rest?
Mm.
And so he dragged her through the mud and through the court, and it was a big nightmare.
Well, we talked earlier about movies about guardianship and stuff. Don't believe what you see in the movies about the reading of the will or estates and stuff. That's not how it goes. The average estate takes at minimum 18 months because of the tax reporting that has to go on with it. So And then, distributions. There's a priority of distributions and how people get repaid. The IRS is going to take the money before anybody gets
Right.
anything.
The beneficiary can't just take their share because you have to pay the bills and you have to pay the taxes and you have to marshal the assets. You have to gather everything up. So there's a lot of work to do. Thank you for talking about all that stuff. I bet you didn't realize how fast this would go.
It went really fast, but I mean, this is second nature to me. I love doing the accountings.
Yeah. So I want to talk about legacy now.
And now, it's time for the Talk Law Radio Legacy Spotlight. What's your legacy? Sponsored by Marquardt Law Firm.
So for today, I'm not going to ask you about your legacy.
Okay, good.
I'm going to talk about how to leave a legendary legacy. And that's by doing all the planning that we talked about in the second segment, having a durable power of attorney, medical power of attorney, last will, living trust, just having everything in order. Tell us, can you remember a time where you saw somebody who didn't know where the bank accounts were, didn't know if they had life insurance, didn't know how much the bills were going to be, versus somebody that had all of that stuff in order? What's the difference in how things go?
The difference is chaos. I tell everybody that serving as a guardian or the executor or trustee, it's a full-time job. It can be exhausting. And, if you can plan accordingly and have the conversations with your family that need to be had, nobody wants to have them, but it has to happen. You are giving your family, for potentially generations, the greatest gift that you can give them. And you're teaching them that proper planning prevents the chaos.
Right.
It gives you peace.
And it helps to preserve family harmony too. Because when there's chaos, that's when people argue. They start pointing fingers. This is your fault. You didn't do this. You didn't do that. But when you have everything in order, then they can be proud of their parents or their loved ones and say, wow, this is really easy. I'm so glad that they took the time, spent the money to do this planning up front.
And be honored that they think of you in that time. Nobody wants to think about their parents passing away. And this is one less burden that you can give to your children in that time.
Amen. Well, is there anything you want to say to the audience in the last 30 seconds? Some soapbox issue?
Get those estate plans done. If you have a child that is 18 or about to turn 18, start doing it for them. My oldest is about to go off to college, and we've already told her, you're going to have these documents in place before you go.
Yeah, you never know when something bad might happen. God forbid. Thank you for joining us. I'm Todd Marquardt. I'll talk to you later.
Most families don't realize they have hidden legal blind spots until it's too late. Wills, trusts, Medicaid planning, even protecting a business. These are the kinds of issues attorney Todd Marquardt helps uncover before they become problems. Todd is the host of Talk Law Radio, where each week he guides listeners through the legal challenges families, veterans, and business owners face, while showing them the practical steps to protect what matters most. Catch Talk Law Radio, Saturdays at 11 a.m. on 9:30 a.m. The Answer, 6:30 a.m. The Word, and now in Houston on AM 1070 and 103.3 FM The Answer, or anytime on YouTube. Planning isn't just about documents. It's about peace of mind, security for loved ones, and building a legacy that lasts. Don't wait for a crisis. Do it before you die.